Hello and welcome back. GovDoc News, no opinions, just facts and summaries of government documents. You take it from there. We are back today. Supreme Court opinion Riley v. Bondi. This is an older one, couple months, but we took a month and a half off there, so we're trying to get everything to you guys as soon as possible. All right, here we are talking about Pierre Riley, a Jamaican citizen facing removal from the U.S. due to an aggravated felony conviction. The Department of Homeland Security issued what's known as a FARO, or Final Administrative Review Order, on January 26, 2021, ordering Riley's deportation to Jamaica. In turn, Riley sought relief from CAT, or the Conventions Against Torture, claiming he would face torture if he returned to Jamaica. An immigration judge granted deferral of removal, but the Board of Immigration Appeals vacated that decision, allowing the FARO's enforcement. A side note here on immigration judges. So apparently immigration courts are not a part of the actual federal judiciary, which I had assumed they were. Immigration courts operate under the Executive Office for Immigration Review, or the EOIR, an agency within the U.S. Department of Justice. The general structure goes immigration judges, then the Board of Immigration Appeals, and in rare cases, a review from the Attorney General who appoints the judges to their posts. But the main thing we take away here is that they are operating under a federal agency, so appeals to their actions and decisions go straight to the circuit court at the federal level. Remember, district court, circuit court, Supreme Court, anything to do with a federal agency skips the district court, goes straight to the circuit. All right, back at it. So the immigration judge granted relief from the CAT, and then the Board of Immigration Appeals came in and said no. And they did this saying that Riley did not meet the deadline for filing an appeal set at 30 days under 8 U.S.C. 1252b1. This is one thing being challenged by Riley. FARO versus the Board of Immigration Appeals decision. Basically, there is a 30-day appeal deadline, and the clock on that starts when the FARO is administered, since it is considered the final order in immigration proceedings. Riley is saying that the Board of Immigration Appeals decision should be the final order, and the clock start at the conclusion of their decision, not when the FARO was issued, which can be more than 30 days before the Board of Immigration Appeals decision. The other question is around the 30-day deadline itself. The courts have treated this deadline as a jurisdictional requirement, which basically means something that has no wiggle room, a rigid rule with no flexibility.
Full video located on our channel.